Welcome to our continuing YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we will be discussing a situation where your company or partnership has been sued and what you should be looking in general terms to do. So the first thing you want to do is not to panic. You don't want to act in haste. You don't want to make any rash decisions, especially when there's other people involved in this business matter. Nevertheless, the first thing you want to be doing is taking a step back, taking a deep breath, understand where you're at. Don't engage the other side, but engage independent legal counsel. Whether your company or partnership has an existing lawyer, they might not necessarily be a litigation lawyer, maybe a corporate lawyer, an employment lawyer. But you want to be engaging that lawyer and finding out from them specifically, under solicitor-client privilege, what should you be doing with respect to your company, your partnership, or your business, given the fact that you are just receiving a lawsuit, a statement of claim, a complaint, and your company is now being sued. Potentially yourself as a director, officer, and shareholder might also be sued in this same complaint. But you want to take the step back. You don't want to operate in haste, and you want to first be speaking with legal counsel who can give you the guidance, but also set your mind at ease as to how you're going to look to tackle this situation. So this brings us to the second point, and we already touched upon it. You do not want to talk to anybody else, anyone, outside of first speaking to the lawyer. And this is after the lawyer tells you that they can advise you and they can be engaged by you. You don't want to be talking to anyone else. That includes friends, family, therapist, psychologist, your priest, your accountant, anyone. You don't want to be talking to them immediately at the outset. You want to start by talking to your lawyer. You want your lawyer to provide you with the initial guidance as to how you initiate and proceed. And most importantly, you do not want to be talking to the other side. Whoever initiated the lawsuit will hope that you jump the gun and start talking to them, whether it's talking to the partners in your business who initiated the lawsuit. It is the lawyers on the other side, although they'll typically say, unless you're represented by counsel, they won't take your call. Nevertheless, you don't want to be talking to the other side. You don't want to be talking to the other business owners, the company that has filed the complaint. Do not talk to them. You got more than enough time, although time is always essential. You have more than enough time to talk to your lawyer, get direction from your lawyer, and let your lawyer provide you with the guidance and direction as to what the next step should be. It's absolutely critical that you take that advice steadfastly. And you're already seeing the importance of engaging legal counsel, and we're going to address this later, but legal counsel is pivotal to these scenarios. Now, the next thing you want to do is you want to safeguard all the evidence. You don't want to start destroying documents and emails and records and the like. That is illegal. The court comes down hard on it. It's highly improper. And the fact of the matter is, there are many ways in today's day and age to identify if there has been any destruction of evidence, any hiding of evidence. And the critical thing on top of that is that if there is, as of the date that you get served, if you start discarding stuff, those major gaps will come out and look horribly bad for you before any judge. It will reflect bad faith and an effort to destroy evidence, and what might have been minimal at best, or might have been inconsequential to the whole matter, can be misconstrued and misinterpreted as something that is essential to the whole matter. So you don't want to be destroying anything. Even if you have normal destruction policies as to destroying emails, documents, you want to stop all those immediately, not destroy anything more, not delete anything more. You want to keep everything, because they can go look into your systems, and if they start seeing deletions and they don't know what those deletions are, they're going to be read against you, and it's going to become extremely problematic. Furthermore, you're going to want to be collecting all this material and providing it to your lawyer to work with, to protect yourself, to preserve your best interests. Meanwhile, another essential element is to preserve your memory. You want to speak with your lawyer, find out the best method that he or she wants you to record what your memory is. But nevertheless, you want to start putting it down. The fact of the matter is that these legal battles in court can drag on for years. It can be 5 years, 10 years. It's incredibly long these days. And you don't want to be trying to recollect events that are critical to this years from now. You want to be putting it down concurrently as soon as you can. Because even in a few years, oftentimes when you're starting to do depositions and questioning, your memory can get tainted. You can get impacted by the changing events, by the pressure of this lawsuit, and the other approach that the facts are presented to you by the other side. And you start to manipulate your own fact patterns. This is problematic for yourself. Instead, what you want to be doing is preserving your memories and putting it down now, because it's going to create the closest set of facts to the actual facts outside your memory. And it's going to be the most consistent. This is what you want to do. You don't want to be coming across as having two sets of facts. The ones that actually transpired and the ones you're recollecting after 4, 5, 6, 7 years. It's not good. So you want to be preserving those memories, and you want to speak to your lawyer, get their guidance, and put it down. What else do you want to do? Well, another important thing is you want to notify your corporations or your partnerships insurance carriers. There are specific notice provisions within almost every insurance policy, and they require the insurance carrier to be notified accordingly. If you don't notify them in a timely fashion, as required by your contract, you could well lose out on the insurance. And this is an important thing to do, but also to do it and have a written record of it. The fact of the matter is that many insurance carriers will have their representatives tell you there's really not much we can do. But you should not simply say, okay, and move on. You want to have a written record of what their position is, so that when you speak to your lawyer, they might say at a later date, your insurance carrier really should have picked this up. And you don't want to say, well, I think I made a phone call to them, and you don't have a written confirmation that the insurance carrier was not looking to take it on at that time. So what you need to be doing is contact your insurance carrier, get written confirmation, follow through with them, and proceed accordingly. Now, if your insurance carrier does retain legal counsel on your behalf, you will nevertheless still want to retain your own legal counsel, even though the insurance carrier might well be working to protect your interests. they are also protecting the insurance carrier's interests. And this is something you have to be aware of. You need to make sure that your interests are properly covered and that you have legal counsel who explicitly and specifically is committed to your interests above all others, and actually to the exclusion of all others. Because the insurance carrier may have interests that differ from yours. And you have to also remember that where the insurance carrier is paying for the lawyer has loyalties, whether explicit or implicit. They may not outwardly say it, but the thing is, they may well have them with respect to the insurance carrier. What you're wanting is to have the unfettered legal advice of someone who is only committed to you, who is exclusively committed to yourself. And this brings us to the need for competent legal counsel. You want to have your own lawyer. You want them to be admitted to the jurisdiction in which the battle is being fought. And you want them to have the experience in the field that you are looking to tackle. This is absolutely important. Sometimes companies and partnerships have lawyers who fulfill other functions. They may not be in the realm of business dispute resolution. They may be corporate lawyers simply focused on corporate transactional matters. They may be real estate lawyers. They may be divorce lawyers that they know, criminal lawyers. You need a lawyer who is specific to the business matter you have. And why is this important? Well, it's actually important not only from a success potential, but is also important from a cost perspective, because getting the wrong lawyer means that they're going to be doing more work than necessary. They're not going to have the tools available to serve you, the knowledge necessary to articulate your position most effectively and deal with challenges when they arise. So you really need to get the competent legal counsel that is appropriate to the matter at hand. And as always, you need to remain cognizant of your time constraints, which are typically set forward in the paperwork that you receive as to when there are filing deadlines. Although once you engage legal counsel, your legal counsel may well be able to get extensions with respect to initial filing deadlines when they contact the other side's lawyers and get the okay from the other lawyer to properly proceed with preparing and filing your company or partnership's defense. Now, these are but a few of the essential elements that you need to be undertaking immediately. I understand that a lot of this has been presented in a very generalistic format, and that is a consequence of every lawsuit being highly specific to the matters before the parties. So you don't want to, in anything you do, in anything you review before undertaking action and getting specific guidance from a knowledgeable lawyer who understands your facts, you don't want to be relying excessively on generalities. And YouTube videos like this, websites, printed materials, PDF overviews are generalist. They do not specifically address your specific facts. So you have to take everything with a grain of salt that you read or you view or you hear until you have engaged a competent lawyer who sits down and tackles the specifics of your particular case. Then and only then will you have the proper direction. But at the same time, what is provided in videos like this should give you some sense of where you need to put your focus on and your attention, and help you try to avoid certain easy to make mistakes that could cause you problems going forward and could put your company, business, partnership, or otherwise in harm's way unnecessarily when it was entirely avoidable. I trust you found this YouTube video informative. As always, feel free to contact yourselves with respect to matters pertaining to business law, and we look forward to speaking to you again. And if your business, company, partnership has been sued, we hope you engage effective legal counsel and the results that arise from that litigation are successful and favorable to yourself. Thank you.